Well, good morning and welcome to the Pacific Salmon Foundation's inaugural virtual estate planning program. As a bit of primer, PSF is a nonprofit. We're based here in BC, and for the last 33 years we've been dedicated to the conservation and restoration of wild salmon and their natural habitats in British Columbia and the Yukon. If you tuned in earlier, hopefully those slides that you saw highlighted just what we're up to as a nonprofit organization, all the work being done by volunteers throughout BC to protect and restore one of our province's lifeblood species, wild Pacific salmon. Well, during the past 2 years, we've been presenting these estate planning programs in a number of communities in BC. We've talked with hundreds of interested attendees. Folks that care about the environment are also interested in their estate planning. But now, of course, with COVID, we're pivoting like everybody, and we're happy to present this session to you in the comfort of your own home or office. As you'll hear from our expert speakers today, this pandemic has sparked conversations about the importance of powers of attorney, representation agreements, and wills alike. All topics and more that we're going to cover today in our session on estate planning. We have three speakers today. Devinder Sidhu, who's a barrister and solicitor based in White Rock. Gardy Frost is a professional financial planner with Arbutus Financial Planning. And Michael Todd is the charitable investment director with Charitable Impact, and that's a donor-advised fund. And they're experts on philanthropy in general here in BC and all across Canada. We'll be sharing their knowledge and their expertise in this very important part of conversation around financial planning. Now, following our presentations today, there will be a question and answer session for you to ask your questions, and those will be shared on screen. We're using the Slido system, which you will see on the screen, slido.com, and the hashtag salmon. You can submit your question and also vote on questions for the Q&A session. So let's start with an overview of estate planning, and we're going to ask Mike Todd to open things up for us today with a bit of a high-level overview. And then actually after Gardy and Devinder are done with their presentations before our Q&A, Mike's going to give us a bit more context as well. So Mike's going to talk to us a bit about his insights on what industry professionals are noticing these days with wills and estate gifts. So Michael Todd, welcome, and over to you.
Great. Thank you, Mike. It's a pleasure to be here, so thanks for having us. These are interesting days, obviously. What we're noticing, particularly now with COVID, is a couple of things. I think that we're seeing more people wondering what they can do to help. And, I work in the charitable world, so they're calling us up and they're saying, listen, the world is in a mess. I feel like I need to do something. What can I do to help? So from a charitable perspective, that's what we're seeing. I'm also hearing anecdotally from some of my estate planning lawyer friends, from my financial advisor friends, that people are inquiring more about wills and writing a will, and that is fantastic news. I think for a while now that in Canada, we've had rather low levels of will writing and people without wills, and people that just amaze me when I have conversations and they'll admit to me that they don't have a will. And so we really want to see that change. Right now in Canada, from people of 35 years and older, 56% apparently have a will. And to me, that's alarming and it's shocking. And so we're hoping today to make a little bit of a difference with that. Of course, I look at the world through a charitable lens, and apparently 82% of Canadians say that they give to charity annually. But speaking of wills, only 5% say that they are leaving a gift to a charity in their will. And that's quite a spread. And again, today we're hoping to educate a little bit on that. The problem apparently is that most of them know that they can. Many of them say that they are interested, but alarmingly, 2/3 say that they're not interested. And when they're probed, there's a very interesting problem that is revealed. And people will say, and I've had these conversations myself, that they have favorite charities they want to support. They've supported their whole lives. They would love to be able to do that in their will, but they're planning on leaving their legacy to their family, and they don't want their family to be negatively impacted. And so clearly there's this belief that it's one or the other. And I'm here to say that it doesn't have to be that way. It's not black and white. You can do both. And the solution, I believe, to that is to look at your charitable giving as part of your comprehensive financial plan and work with your advisor and figure out a way that you can do both, and nobody suffers. You can support your favorite charities, you can leave a legacy to your family, and you're not shortchanging anybody. It's quite interesting. We find, well, we know from our conversations that charitable giving is an extremely personal thing to talk about and to think about. But once you've made that decision that you are going to give, then we would love to see people treat that very, very professionally, not personally, but professionally. And as I said, make it part of your plan. Try to do it as effectively and efficiently as you can. There are smart ways to give, and there are ways to give that are not quite as effective. So again, speak to your financial advisor. But when it comes to planning for what comes next, planning for the legacy that you're going to leave, we really do believe that you can do both, support your family and support your favorite charities.
Well, that's very helpful, Mike. One of the things that we notice at the Salmon Foundation with people that have made estate gifts to us and they've notified us while they're living is that they talk about the satisfaction of giving both while they are living through charitable giving, tax receivable, but also having the satisfaction of knowing that it's part of their legacy, beyond them. And I know it may make it incumbent upon charities to not just be speaking to the baby boomer generation that are the strong givers right now, but also to be building relationships with their children. Is this something that we're seeing and hearing more of with charities?
Absolutely, Mike. Yeah, and this is a great opportunity to involve your children in the financial aspect of your family and the legacy aspect.
Yeah. Well, and Mike, thank you for making note of the need to think about this from both a financial planning perspective and a legal perspective. I know many people often just think, oh, well, this is a legal document I have to file, put in the safety deposit box. But really it is about the financial planning and the legal planning. And that's, of course, why we have today with us two experts, one in law and the legal side of things, but also one on the financial planning side. And so we're going to move to our legal expert now. We'll come back to Mike Todd a little bit later to wrap things up for us before our Q&A, but we're going to start with our legal conversation right now. And we're going to go to Devinder Sidhu, who I mentioned earlier is a barrister and solicitor. Hello, Devinder. Thank you for joining us from your office in White Rock.
Hi, Mike. Thanks for having me here today.
And both Devinder and Gardy Frost, who are with us today, have spoken at previous sessions that we have. So we know you have great intelligence because people have told us how useful it is. So Devinder, thank you very much. We're going to start with a very basic question. There are notaries, there are lawyers, both can do wills. But tell us, what can these individuals do? What's the main job and the service that they provide in the context of estate planning?
So it's basically giving you peace of mind that your will is valid and that your estate will be paid out how you want. And it gives you control. You get to decide who gets what and who is in charge. And a properly done will definitely give you that. And I have seen people do it on their own. They use will kits and that sort of thing, but I've also seen it where it maybe wasn't done properly. One particular one I can think of is where they did everything. They appointed executors, they listed their family, but they missed the key step of outlining who actually got what. So they didn't actually distribute their estate at all. And both notaries and lawyers can help you prepare wills. And the main difference is that lawyers can do trust wills. So let's say, for example, you're not comfortable with beneficiaries inheriting at the age of 19. You think that's too young. So a lawyer can help you prepare a trust will that holds the assets in trust for minor beneficiaries. Well beyond the age of 19, they could inherit at the age of 5 or 30 perhaps. So that's the main difference between notaries and lawyers, but both of them do draft wills here in BC.
Okay, great, Devinder. And we've all heard, of course, the horror stories of people who don't have wills and they have minor children and the spouse is left to deal with the courts and the probate process, which is not pleasant. And of course, there can be pitfalls with not having a properly done estate plan and will. So walk us through what are the basic elements of an estate plan. If you're brand new to this topic, what are those basic elements that you have to have in an estate plan?
Sure. So an estate plan is, broadly speaking, it's basically the process of preserving, managing, and distributing your estate for after death and for incapacity. So the main elements of that is a will, a power of attorney, and a representation agreement. So the will is for after you pass. It doesn't take effect until you die. The other two documents, the power of attorney and representation agreements, are for when you're alive. And those actually end when you pass. But those are the three main pieces. And your will doesn't necessarily cover property. It basically covers items of any kind, whether it's land, vehicles, or digital assets, things that are owned by the deceased alone, typically. It does not typically cover property that is not owned exclusively. For example, we've got joint bank accounts or jointly owned property, such as a home that automatically passes to the surviving spouse. There is a disclaimer that I have to mention, though, because that isn't always the case. There is a Supreme Court of Canada decision that says the fact that an asset is held jointly with the right of survivorship does not automatically exclude it from being an estate asset. It depends on the evidence. But typically speaking, the will does not cover jointly held assets. And then you also have things like registered plans or life insurance policies where you can name a beneficiary. So the named beneficiary gets that asset, the estate pays any taxes, but that asset passes outside of your will to the designated beneficiary.
Okay, very helpful, Devinder. You know, my wife and I did our first will when we had our daughter 14 years ago. And the main thing that I walked away from that first experience of developing our estate plan at that time was the need to keep it up to date because, you know, our situations change. Hopefully they're changing for the better as we go. But talk to us a bit about, you know, you can't just do this thing and then you put it away and never think about it again. Talk to us about, you know, what triggers when you need to revisit that estate plan.
I do recommend that people review their will on a regular basis. Every few years, make sure it's current. Read it through, make sure it still says what you want it to say. I have seen people with wills that were 40-year-old and they were still fine. Then I've also seen people where they update their will on a regular basis. So review it every few years and then also after certain life events. For example, the death or disability of an heir, and think about whether your executor is still able to fulfill that role. Maybe your marital status has changed. There's other things such as the birth of a child or grandchild. Maybe you've retired. Maybe there have been changes to the law. Maybe you've moved to a new province or country. And then if you're appointing a charity, sometimes a charity's name has changed. So you should always kind of review and update, take a look at it on a regular basis and make sure it still says what you want it to say. And then when you are drafting your will initially or redoing it, you want to make sure you spend enough time with the person you're working with to discuss your assets, your liabilities, and overall speaking as to your intentions, your objectives, so that the person who's helping you will have enough information to make sure that your estate plan covers everything. And it tries to cover any unanticipated risks, any unnecessary consequences, and you want to make sure that your gifts are going where you want it to go. And what we try to do when I'm working with someone, I try to make sure that the will speaks for as long as possible, because you never know what will happen. If you've lost capacity to change your will, you want to make sure that the will that you set in place will speak for as long as possible, and try to plan for anything that could occur down the road.
Okay, great. You know, there's so many important elements to this. This really is why you need to speak with professionals, financial planners and legal professionals. Talk to us a bit about what happens if you don't have an estate plan, if you don't have a will. What's the law say about this, and what are some of the particular challenges associated if you don't have will? I know we've had some friends, unfortunately, who have children. One of the partners died, and it just made things very difficult. Talk to us a little bit about the worst case scenario, I guess.
Yeah, so it can get quite messy if you haven't planned for who gets what or who's in charge. So if you don't have a will, then you basically died intestate. And there are rules as to what happens in that scenario. Your net estate is distributed, to your next of kin according to the Wills, Estates, and Succession Act. So the legislation is the one that decides who gets what, and it depends on whether you had a spouse and children of the marriage, children not of the marriage, and some people pass away with two spouses. For example, they may have ended one relationship but didn't end it legally and are still in a common law relationship with someone else. So then those spouses end up sharing, and that may not be what you want. And so your wishes may not be met. Your taxes could be higher. Your minor children may end up having to be managed by the public guardian and trustee if you haven't appointed a guardian. And even if you have a will, it could be that some gift fails or some portion of your estate fails. And so your estate can end up passing by intestacy. So sometimes what people do is they name a charity as a catch-all or a fail-safe beneficiary. So at least your estate, even if part of it fails through your will, at least there would be, it would be going somewhere to a charity that you support rather than through the government legislation that kind of dictates who gets what. So it's very important to plan ahead of time, make sure that you have control over it rather than relying on the legislation. And then someone has to be appointed administrator, which is like an executor, and they have to go to court to be appointed that. Whereas if you had a will, you could name your executor.
Yeah, and tell us more about the job of an executor and their importance in this context.
Yeah, so an executor has, they're basically responsible for finding your will, locating your beneficiaries. They protect and maintain all of your assets until it's ready to be distributed to the beneficiaries. They have to safeguard your estate. For example, they have to maintain or renew your house insurance. If your residence is unoccupied, they have to make sure the strata bills are being paid if it's a strata property. They gather up your assets, such as your bank accounts, investment accounts, your life insurance. They can arrange for professionals to appraise the assets to determine the value. They arrange for your funeral. They pay out any of your debts, such as credit cards. They arrange to file your income taxes, pay any taxes owing. They work with an accountant. They work with your different advisors. And then basically after all that is done, they've gathered up all the assets, they've paid out all the liabilities, they divide what remains of your estate among your beneficiaries. Those are the people or the charities that you've named in your will. They divide it according to what your will says and any other duties that might be specified by the will. And the executor, depending on whether your estate has to go to probate or not, they would also be part of that probate application process as well.
It's a big job.
It's a very big job, yeah.
A lot of work. I mean, obviously, it's an honor to be asked by someone to be an executor. What should people be thinking about when they're choosing an executor? What should they be looking for?
When you're choosing an executor, you want to pick someone that you trust completely, and you also need to pick someone who will likely be alive when you pass away. So it's usually someone younger, a trusted family member or a trusted friend. And it's, ideally the executor should live in the same province or area as you if possible, preferably Canadian resident for, tax advantages. And sometimes if it's a big job, sometimes people name more than one executor at the same time. Or what they do is they name an executor and an alternate after that if the first executor named can't act. It is very important to always think of alternates. So if the executor named cannot accept the role, then you've built in alternates or even a chain of executors to who can take over in those scenarios. And if you have a complex estate or investments or particular circumstances, you may have a company that you need someone to take over the operation of if you pass. You can always consider a professional executor as well. You could think of a lawyer, a notary, an accountant, or a trust company. Sometimes the banks have trust branches that take on the role of executor as well. And then there's private trust companies as well that are professionals who do this for a living, basically.
Okay, that's great. Deviner, what's the difference? I know this comes up a lot. Tell us the difference between an executor and another common role or phrase here, the power of attorney. Tell us what power of attorney means compared to executor.
So executor is sometimes it's the same people. You may be appointing the same people in these roles, but they're two different roles. So the executor, that job starts when you pass, basically, but the power of attorney is for when you're alive. So the power of attorney person is appointed through a power of attorney, and they have the authority to deal with your financial and legal matters while you're alive. So that could include paying bills, doing your banking, your house may need to be sold to take care of your care, and then the power of attorney person is the one who would take charge of that. So they have similar qualities to your executor, but the power of attorney is for when you're alive, and the executor is for when you pass on. And the power of attorney can be revoked at any time as long as you have capacity to do so.
Okay, and are your wishes for while you're alive covered in the will, or is there a different document that covers desires and wishes while you're still living?
The power of attorney is for the financial and legal matters. There's a separate document called a representation agreement. That's also for when you're alive, and it covers your personal care, health care wishes. So that covers things like surgeries, treatments, long-term care, diet, preservation of life, that sort of thing. And so that in the representation agreement, you're appointing a person who would make these decisions for you if you can't do it yourself. And so for some families, it can be the same person in all three roles, but they're all different hats that they're wearing. The power of attorney person, you're wearing the financial and legal hat. The representative is wearing the personal care, healthcare hat and making those decisions for you.
Okay, great. And of course, all of these documents we're talking about are properly legally filed documents, correct?
Well, they're proper legal documents. The filing part just depends. There is a wills registry where you can register the fact that you've done a will and where you're keeping the original. With the power of attorney, you might take it to the banks. You might have to file it at land title office. And there are registries where you can file these documents.
But we do know that where the government definitely gets involved is once you are dead and closing out your estate. Government obviously wants to try to get its piece of the action. Tell us about, we hear the word probate a lot. Tell us about how it all works, once you've moved on and the government's looking at your...
So when you pass, not every estate has to go through probate. Someone has to ask for it. For example, the banks will ask for it. Possibly they have their own threshold and rules above which they ask for it, below which they don't. Land title office, if you have real estate, even a percentage of it in your name only, they will ask for probate. So what probate is, it's a court process used to prove that a will is valid. So the executor submits the original will to the probate registry at the courthouse along with supporting documents as part of a probate application. They give notice to whoever needs notice. They file their affidavits. They list the assets and liabilities. The court reviews it all, and then once you pay the probate fees of 1.4% for any gross value of estates above $25,000, then you get the copy of the will with the grant of probate stapled to it, and that basically gives the executor authority to deal with the estate. And if you pass away without a will, then it's called a grant of administration. It basically gives an individual authority to deal with the estate.
Well, Devinder, excellent. We're going to give you a break now. Thank you for all of this information, so useful. I've learned a lot just sitting here listening to you, and I've heard you speak before. But it's good that we sort of transition on this question of probate and fees, and of course taxes. And that's why the financial planning side of things is so important. So we're going to turn to Gardy Frost, who I mentioned earlier. Gardy is a financial planner. His job is to help people as they think about their estate and make sure that as much of their hard-earned dollars are kept in the family, so to speak, or maybe sent to charitable organizations. Gardy, thank you very much for joining us here today. Let's start with this question of probate and fees. what are some strategies that people can employ to keep those fees and, as I said, keep as much money in the family or with charitable organizations as possible?
Thanks, Mike. Thanks for having me today. And thanks for the Pacific Salmon Foundation to be talking about such an important subject, as we heard from Michael Todd earlier this morning. This is a huge, complex area. Probate and taxes are always going to be a part of an estate plan. And as we build an estate plan, we want to take into account what are strategies to help a client deliver on their wishes. What are they trying to achieve? And also do so in the most tax efficient way possible. So probate is, as we just heard from Devinder, something that is often discussed in estate planning, and we never want the probate tail to wag the tax dog. And we always want to make sure that we have the right ingredients in that estate plan. So joint ownership, for example, is a common strategy when it comes to estate planning. Named beneficiaries, we heard Devinder speak about life insurance and RRSPs and RIFs, and having designated beneficiaries helps with the probate process and removing assets out of that mix. Simple strategies may include involving an insurance company to own some assets rather than an investment company or a bank, where there will be different tax treatment of those assets. So there's a few strategies that we look at.
Okay, good. And one of them, of course, is leaving funds to a charitable organization, because we are lucky we live in a place where the government incentivizes this through tax deductions, which can carry on after death. So tell us a little bit about what are reasons that you might want to consider a gift to a charity, and can you suggest some specific ways to do that?
Absolutely, Mike. I mean, most of us are giving to charity on a regular basis, so we're familiar with receiving a tax receipt and filing that with the government. The whole idea of a charitable gift today, first of all, it doesn't cost anything. You can give money that you just have in your account. You can donate more strategically as well. You can give through using swollen gains in an investment portfolio. The government of Canada has designed it in such a way that Canadians can give to charity so they don't have to. And so we, as advisors, are constantly engaging with our clients, much the same way Mike talked about on this very personal discussion about their charitable interests and for whom they wish to leave their legacy to. There's some statistics or some data rather on the slide discussing the specifics about how much can be used to reduce the taxation that you have payable. A gift in your estate, in your final tax return, can be used to offset 100% of your net income in the year of death. So that final tax return is really an opportunity where Ottawa says, listen, Mr. Taxpayer, now's your time to decide for whom you're going to leave your legacy. And Pacific Salmon Foundation is a great example of an organization that needs that donation. So they say, go ahead, give your money to the Pacific Salmon Foundation instead of giving it to Ottawa. That's the direct reason for that tax return, that tax receipt rather.
Yeah, very, very well put. And we certainly can put it to great use.
That's right.
As we know, we have, each year we fund a couple hundred community-based stream-keeping organizations that are restoring salmon habitat, running education programs, and the funding we have available never fully meets the demand that we get from the groups. And certainly, as we know, the situation with salmon is not great, and we've got to be doing everything we can to support it. Yeah. So let's take maybe a step back, Gardy, and help us understand, when an estate plan has been properly done and everything's in order, how is an estate taxed?
Sure.
What happens?
Sure. So when the estate is taxed, we have income in the year in which the taxpayer passes away. We have the capital gains that are deemed to have been sold. So there's what's called a deemed disposition, which means that all of your assets are appraised and the values are set, And it's at that time that you decide whether, or rather that you have a tax bill to pay. So when we plan for an estate, we want to identify what income has the most tax liability associated with it. So it may be capital gains. There's much discussion today about whether that's going to change under the circumstances of COVID right now. But today, at least, your capital gains are taxed at 50% of your capital gains will be taxed on death. Registered assets, on the other hand, registered RRSPs and registered income funds, RIFs, are 100% taxable. And so here's an area where we've got a real opportunity to plan around, taking advantage of giving those RIFs to charities. And sorry, go ahead.
Well, I was just going to ask, Gary, those are taxable 100% because
100%.
that income was not taxed when it was put away in life.
That's right.
So
That's
I'm
right.
putting money in my RSP tax-free, but
And probably you're going to use much of that money when you go into retirement, Mike, and that's what it's for. But the reality is that these investments oftentimes still have money in them when we pass away. In our world, in a partnership, you can roll over assets to your spouse on a tax neutral basis. But on the second to die, that's when the real problem occurs. And so that's where we really want to have the estate conversation to say, here's what's going to happen when you pass away, and what do you want to do about it? And that's where the conversations turn to the charitable interests we have today, the legacy planning that we have, and making sure that we're taking those realities into the plan, because it's very simple to sit down and say, here's what you have. If you live to this age, here's what it's going to look like when you pass away. Well, obviously things can change, and we don't know when it's going to happen, but the planning side of it is where Pacific Salmon Foundation really can be a part of be a part of that.
yeah, and we are happy to have conversations with people as they are going through their planning process, of course. Some people are interested in supporting particular types of projects, or they have a particular region,
Yes.
maybe somewhere they were from or a place they like to holiday in the summers. And because we have a reach all across British Columbia with our program, and we are able to actually help people direct to a degree funds that they might leave to us to projects that they can have the confidence that it's going to be really meaningful to them.
Yeah.
So let's talk a little bit, Gardy, about what happens. How are these tax receipts that a charity can issue treated for tax purposes in this context?
So I've got my slide here. What happens is when you, the question was, how are the receipts treated? Well, you receive the receipt and it's used to offset the tax payable in the year in which you're filing your tax return, I think is the question you're asking.
The last year, your last, what
Yeah,
did you
so-
call it, your final tax return?
Yeah, we've got the ongoing tax returns we file every year.
Yes.
And that's where we can use a tax receipt. It's eligible for 75% of our net income can be used to reduce that tax payable. In our final tax return, we can use 100% of that gift.
Okay.
And so that's where that estate plan, the final donation can really have value. And it's interesting, Mike, you mentioned about, particular regions or areas that people want to support. And I think one of the misunderstandings around charity is there's also this administration piece to charity, which is a huge component that it's not discussed very often, is that it costs money to have a Michael Manier run it. It costs money to put on productions like this. And so charities are needing money, not just for that river system that needs help or the Stream Keepers project in the Seymour River, but also to keep the lights on and keep the operations running. So there's a lot of different ways you can give to charity, and you can create scholarship funds. You can. Michael was talking about involving children in the process. I mean, this is a time where we all are reviewing what's important in life to us and who's important to life, and having your children engage in that conversation and why you're giving to a Pacific Salmon Foundation today is one question. But when you design an estate plan, you have a legacy decision to make, and for many it will hopefully be a donation to the Pacific Salmon Foundation to actually continue on so that children can catch salmon the way their parents did or grandparents did.
Well, you're a good example. Your dad's been a volunteer with us for many, many years, now serving on our board, and we are beginning to hear from our donors. These are generally folks who are in the baby boomer category. They're in their 60s and their 70s, and they're now introducing their children to us so that the children are at least aware of our mission, how we operate. And this is happening more and more. I've been seeing this in the last few years, and it's a wonderful thing.
Well, I expect it'll be more now through this COVID period. I would think it should be a benefit in some respects to better strategic planning and gifting.
And really important for charities to be open to those kinds of conversations.
That's right.
And be engaged in the estate planning process as much as possible. I mean, this is the thing that we say to people sometimes. It's great. Thank you for doing this for us, but let us know what you're thinking.
Yes.
And what your interests are and how you want us to use it, because we obviously want to make sure that we honor the plan that's been put in place for the legacy.
Yeah.
You're really providing us very helpful information here, Guardian. The slides, of course, will be available to people afterwards who want to look a bit more into the details. There are ways you can strategically use a charitable donation or tax receipts after you've moved on. Tell us a little bit about the strategic side of things.
Yeah, I mean, the strategic side of things in many respects has to do with that plan and knowing what you're facing down the path. If you've got, I used the example earlier about the RRSPs and the RIFs, and you can donate that RRSP, which is 100% taxable in your estate, and receive a full credit, tax credit from the government for that donation without having to realize that liability inside your estate. People that have had very successful companies that they've invested in, where you are eligible to, when you sell those stocks, for example, you would have capital gains that would be payable. Those stocks can be gifted to a charity directly, and those gains won't be payable. The taxes won't be payable in your estate. Instead, you'll receive the donation from the charity to offset that tax.
That's very good. So let's talk about just in general ideas for how you can leave a gift in your will. I know there are other options like a life insurance policy. Tell us about some of these options that are available to people that they may not be thinking about.
Sure. So life insurance, we typically think of our family and our loved ones, but life insurance can also be used to give directly to a charity. You can name a beneficiary. You can give a life insurance policy while alive, and every year that you pay that insurance company for the premiums, that money can be used as a donation to the to the charity. You can give a life insurance policy on death, which would be the time we most often think about giving life insurance policies, where on death the death benefit is issued to the charity, and the charity then issues a tax receipt to the taxpayer or the beneficiary, not the beneficiary, sorry, the owner of the policy.
Yeah. So just so I have this right, so if I have a life insurance policy and I put in my estate plan that I'm going to donate it to the charity upon my death, I can actually get a tax receipt for paying the monthly premium. Is that accurate?
So you can do one or the other.
Okay.
So if you're gifting the charity the policy on death, the charity receives the death benefit.
Yeah.
Then that
receipt is used against the estate.
That's right. That's right. And in our final tax return, that's a really valuable tool, because that's when we oftentimes have more liabilities and debts owing to Ottawa, which is why we see that more commonly used.
And this is why people need to come in and talk to you. Everybody's situation.
You're absolutely right, Mike. You sit here and you want to help people make good choices, and it's not an easy thing to do, because I just don't know enough details to point you in the right direction. So,
well, hopefully people pick up the phone and make a Zoom appointment with you to talk about this a little bit more. Now, you put together, the slides you've put together are really helpful. Again, we'll make those available, but you put together a slide on possible taxes on estates. Can you talk to us a bit about that, give people a better sense of what are the potential tax implications on estates?
Well, as we mentioned briefly, the RSP and the registered assets have a tax liability with them on death, on the second to die, as we mentioned. When you have real estate. Many people here that are associated with Pacific Salmon Foundation have cabins where they go salmon fishing, and those properties are, as second properties, have capital gains that oftentimes are a source of liability for tax purposes. And so, you really need to identify what you have, where you want it to go.
Yeah.
And then how best to do that. And it sounds kind of straightforward, but really what people need to do is understand what happens. And we have lawyers and accountants that can help us articulate these in real numbers, and in this is what's going to happen when you pass away. So helping people to understand what each asset inside their estate, everything that they own, and how it's treated will help us understand, hey, listen, if we give $100,000 to the Pacific Salmon Foundation, that's a direct $100,000 that we're not going to have to pay in taxes. And so that's where we really want people to understand what they have and how it's all treated differently. So everything has a different tax treatment. And you mentioned the investments in registered investments. Those no tax has been paid on those. So Ottawa's expecting there to be tax paid when that money comes out. And that's where giving that to charity is a really strategic move, because you don't have to pay that tax on all that growth.
And as you say, those RRSPs are registered accounts. For the first to die, they can be transferred to the surviving
That's right.
spouse.
That's right.
Without the tax implication. It's
That's
only
right.
upon that individual, the second to die, that the tax implications kick in. But
That's right.
being clear about, because it's 50-50 shot, who's going to go first, right?
Well,
being clear about what you personally value and what you would like your partner to do, charitably or otherwise, is really important. I would imagine these conversations. Difficult, but important.
Absolutely. My wishes and my wife's may differ, so we've got to have a
Imagine
discussion
that.
about that. It's happened. So we want to have a conversation so that everyone is on the same page. And things can change. And as Devinder mentioned in a will, your will plan changes, your estate plan could change, the guardian for your children may change. All these forces of life are going to happen, but the constant is the Pacific Salmon Foundation.
That's
Mike,
right.
And that's what we're here to talk about today.
Well, and you made the point too about real estate, property. I mean, anybody that's lived in Vancouver for more than a year knows
That's right.
that this is a big asset for anybody to own a piece of property or real estate. And many of them, if you've lived here for generations, your family's been here, things have really increased in value. So
That's right.
thinking about those as assets for charitable purposes, well, I've heard stories, it's never happened to PSF, but where people will own a piece of property and actually donate that
Yes.
to the charity. And the charity can then decide, is there a way that we can use this for our mission, or would
right.
we then want to sell it and use those proceeds for charitable purposes? So glad you mentioned that.
And that's really an important reason to engage in the charity in advance of the planning, so that might be wonderful to inherit this piece of land, but that comes with liabilities that the charity needs to be eyes wide open about.
Yeah, that's right. Gardy, really helpful. And the slides in particular, we're going to come back to you obviously in the Q&A. So thank you, Gardy. Thank you, Devinder. Mike Todd, let's come back to you. We've heard a lot here, really powerful and informative stuff. You run a donor-advised fund, so you have a variety of families, individuals that pool their charitable money with you. What were some key highlights that you would raise for the audience here that came out of what you heard so far?
Yeah, thanks, Mike. It's great. I mean, my head is spinning. I'm sure other people's are as well. And our hope is that you're learning something here. And we've talked about legal issues. We've talked about financial issues. We've talked about donor-advised funds. What's that? Well, very simply, that's a giving vehicle that allows people to donate today, enjoy the tax benefits that Gardy has referred to today, and then disperse those funds to charities over time. So just so there's a little bit of background there. Let me go back to something I said earlier, though, and that was when I referred to the fact that charitable giving is a very personal thing. And yet here we are talking about laws and accounting, and some people think, well, I just want to make sure that the Pacific Salmon Foundation has a couple of bucks at the end of my life. Well, don't get discouraged by that. You don't need to be a legal expert. You don't need to be a financial expert. You don't need to be a charitable expert. There are folks like us out there who want to help you. And as Mike has said continuously, have the conversation. Let people know what it is you want, what kind of legacy you do want to leave. And our jobs effectively are to honor your intentions. And so have those conversations. Make sure the I's are dotted and the T's are crossed, absolutely, yes. But there are people who will help you with that. Just let people know what it is you want to do, what you want to leave, and we will make sure that that happens.
Yeah. And Mike, great point on that, the topic of having the conversation. One of the questions, we're going to move to the question and answer session. One of the questions that we've had is, how can I raise the topic of estate planning with my parents or grandparents? And that's really interesting to me, because that's implying to me that this is a younger person who is thinking smartly. I got to have a plan. Hey, that's great. But obviously in this context, they're also thinking about, and we know this is so true with the younger generations, they're really focused on making a difference in the environment, making an impact socially. So how can this young person start this conversation about estate planning with their mom and dad or grandparents?
Great question.
And we can go to Mike. We'll go to you first,
Sure.
and any of the panelists can speak to this.
Yeah, that's a beautiful question, in fact. And I think often people are afraid to have those conversations because effectively you're talking about a loved one's death, and it scares us off. But I hope that we don't let that happen. Personally, the conversation as you've positioned it, I would talk about my grandparents' life and what I have seen from them, what I have learned from them, what is clearly to me has been important to them, and then have the conversation about, what do you want to leave behind? And not to me, your grandchild per se, but what is it you want to leave? What mark do you want to leave on the world based on what I've seen and the way you're living? And then help guide them to some of these experts and start that conversation.
Yeah. Okay, Mike, that's very helpful. And I suppose, Gardy, too, this may be one way this person could start the conversation is to acknowledge how hard mom and dad and grandparents have worked.
Absolutely.
Your thoughts on
Absolutely.
how to start this?
I mean, it seems silly, but if someone's taking the time to watch this presentation right now, what a great time to have the discussion. Listen, Mom, I was just at this presentation today learning about estate planning, and I just was reflecting on my own estate planning, and I give to the Pacific Salmon Foundation routinely. Why don't we, what do you want? What are you doing? I mean, it's a question. It's a conversation. It's not easy. I've heard people do it at real life-changing moments. I had a baby. Now all of a sudden I've got to get a will done. Why do you need a will? Well, I've got this little one that needs to be looked after. Devinder can speak to the situations where things didn't work out because they didn't get the work done. So I think I've heard it. Oftentimes it happens at those life-changing moments. You buy a house, you retire, I think for that conversation, a big part of it is having the courage to ask them about their legacy. And that there's no easy way to do that. There can be lead-ins.
Yes.
It can be a commercial you saw on TV, a movie you saw.
The virtual estate planning session.
PSF virtual estate planning session.
That's right.
Right.
You said something very interesting there. That's a good example of a lead-in, and that was this younger person could do their estate plan, make their charitable giving plan, and then use that as the trigger to say to mom and dad or grandpa, I've done it.
Yeah.
Have you?
And we're hearing that. We're hearing that now that the younger generation is a voice that the parents are listening to.
Good.
So there's a lot of, they came to them for help with technology when they had their new cell phone, and so now the children are actually a voice that parents are turning to for their own questions, which is kind of interesting.
Guardian Mike, this is wonderful. Devinder, we haven't heard from you in a while. Do you have any thoughts on this question, how to start the conversation with older generations?
I was actually going to make exactly the point you made there, Mike, was that you do it yourself and lead that conversation into your parents. Hey, look what I did, and do you have anything in place? And the other thing is, estate planning is not something to do when you're older, because sometimes people wait too late. You never know what's going to happen. As one of my law professors like to say, is that big yellow school bus could come hit you at any time. So you could lose capacity at any time. So what you do is you do your estate planning when you're young and capable, and then you just review it and update it on a regular basis, because you just don't know what life will bring. So if you do it yourself, then you can start that discussion with your parents and grandparents as well, and make sure they have plans in place, and then you're a great example for it.
As we live in the midst of a global pandemic, we truly do not know what might be coming our way. So excellent point there, Devinder. And by the way, I should have mentioned, we do have slido.com, SLIDO.com, and then hashtag salmon. You can visit that website. There's a QR code also on the screen. And that's where you can enter your question or vote on other questions. I wanted to make just a comment too, thinking about the younger generations, who may not have a lot of assets at this particular point in life. Charities can do a lot with a little, can't they? I know at the Salmon Foundation, with our community salmon grant making program, we've gone back and looked at all the grants we've given over 30 years. And for every dollar that we give out, and we're giving other people's money out, like, a donor advised fund, people are donating to us, we're giving it out to good projects. For every dollar we give, our grantees raise another 6 to 7 on average. So, we'll see a gift come in from a will for $10,000, and someone may think, oh, well, that's not it. Well, that $10,000 just turned into $60,000 or $70,000. And I know many charities, particularly grant-making charities, like to have that statistic because it's a very, admirable. It's the power of volunteerism and community service, really. Mm-hmm. Well, let's go to another question. That was excellent feedback. Who should have copies of documents? We've talked about the will on the legal side. We've talked about an estate plan, which, Gardy, I'm assuming this is going to be a written document. Who should you be giving these documents to? Where should they be stored?
Well, the people that need to read them is where they should be. Is who needs to get them. So we often find that we have an important contact document that is who are all the important people in our lives, and we have an important contact person, who are the people you need to speak to, and then where are the documents located. I think everyone has a different answer for that, Mike. It's a tough one. I'd be interested to hear what Devinder and Mike have to say as well, but is it in the bookshelf? Is it, hidden in the secret cabinet? Is it at the safety deposit box? I don't think is ideal. I've been heard cases where that doesn't work as well because the bank doesn't, once you're passed away, you can't have access to that safety deposit box until the executor has permission, and so that can be a bit of a confusing story.
Now, this is something I need to change. Mine is in a safety deposit box at the Royal Bank. Devinder, what about that? That's a really good point that Gardy just raised. The traditional approaches, put it in the safe deposit box. But tell us more. Where should these documents be?
With your bank as well to make sure that they'll let people in, but it can be very tricky. I have a situation where a child kept the parent's power of attorney in the child safety deposit box. Child passed away without a will, and now people are having trouble getting into the safety deposit box to take care of the parent. Some people, what they do actually, if you don't have a fireproof safe at home, some people put it in a Ziploc bag and put it in their deep freezer, hoping that will last longer in case of a fire. And I have heard of a situation as well where they were looking all over the house and they found the will in a Ziploc bag in the crisper. So make sure you always check the freezer, right, for important documents. So some people...
That's great. You heard it here first. Keep your important documents in waterproof bags in the freezer. Okay, that's really helpful. Thank you, Devinder. We'll go back to another Slido question here. And please remember, slido.com is where you can submit your questions and use the hashtag salmon. Here's an interesting one. If I'm legally divorced and I redid my will after my divorce, does my ex have any claim on my estate? Devinder, why don't we start with you? That sounds like a pretty legal question.
I have to have a disclaimer that I don't practice family law, but that should be fine. You're legally divorced, you have redone your will, and I don't think your ex should have a claim, but I would just double check that with a family law lawyer and go through and make sure based on those facts, I think you should be fine. Unless it depends as well, I guess. If you have a separation or a divorce agreement, that would impact, that covers, you have to review that as well to see if that does discuss your estate planning and any claims the ex may have based on those documents.
Okay,
But they
great.
wouldn't have a wills variation claim.
Okay. Gar, do you have any thoughts, or Mike, on that one, or leave that with the lawyer to?
That's all legal, Mike. I know that in BC we have the Wills Variation Act, and so we can have all sorts of cases where people challenge. But the divorce, to my knowledge, is supposed to reduce the likelihood of any claim.
Yeah, only
Okay.
spouses and children have standing for wills variation claims.
Okay, thank you very much. Here's another question. If my will was written in another province, should I update it for British Columbia? So somebody worked and lived in Ontario, they've moved out here, what do they have to do to get things updated?
You might want to look into updating it. Kind of depends on what assets you have in real estate and that sort of thing. But I do know that the probate court does have copies of wills from all over the world. So it might still work in BC, even if you haven't done a BC will. They do accept wills from other provinces. And if you had a grant of probate in a different province or a different jurisdiction, you might be able to reseal it in BC for BC purposes. So it's not the end of the world, but it's always a good idea to double check that based on your that sort of thing.
Yeah, good. And Devinder, is there a, if life's sort of humming along, how often, how many years should people be reopening that will, that estate plan, and taking a look at it?
I would say every few years, just read it through, make sure it still says what you want it to say, and make sure it's accounted for any sort of life events that may have taken place in the meantime.
Okay. Now, Gardy, here's one that's a bit more of an estate question. Can I specify a donation be made from my RRSP? And should I specify this? I don't want to give my entire RRSP away, only a portion. And I'm assuming they mean after they've died. You obviously can't make a donation from your RRSP while you're living, I don't believe. I've never heard of that.
You actually could, but you would have to take it into income
You'd have
first.
to be
That's
taxed
right.
on
Yeah.
it.
Yeah, okay, so obviously
Withholding
that
tax. Yeah, that would
probably doesn't make a lot of sense.
probably not a likely scenario. So
Okay.
you're right. That's probably on death. And the answer is yes. Yes, you can.
Okay, so you can specify a donation be made from your RSP. And again, you were saying that those particular registered accounts, those are 100% taxable
That's right.
upon death. So
That's
that's really probably the first place someone might want to look to
That's
make
right.
a donation.
Right.
Mike, any other thoughts on that one?
Well, I was just going to add, I think the other element of an RSP, and I'm old enough to remember back in the day, the pitch was you put money into your RSP and then you will be able to withdraw it in retirement when you'll be in a lower tax bracket.
Yes.
And folks who have been very diligent about doing that are finding now that A, they have more than they need, and B, they're not really in a lower tax bracket because they have so much. So the idea of looking to your RSP as a tool that you can use for a charitable contribution, I think, is really worthwhile.
Mm-hmm.
Yeah. Okay, good. Now here's a really interesting one, and I'm guessing that we're all on this panel kind of in the same age bracket. You all look young and healthy, just like me. But we're thinking about mom and dad and maybe grandparents that are asking us to be executors. Really good question here from Slido. Can an executor ever be liable for any estate expenses, or how the dispersal is done? Or so, in other words, are there any downsides to becoming an executor? Could I lose money if I'm mom and dad's executor? Gardy, you want to take that one?
I was going to say that should be for Devinder probably.
Okay, yeah. We can go to you, Devinder.
Yeah, there can be downsides, absolutely. But there is executors insurance out there. So if you are an executor, you should look into that and discuss with someone about executor insurance to protect yourself.
Okay,
Absolutely.
that's really, and this is something that obviously, when one is writing up their will, Devinder, this could be considered as part of that process.
Yeah, Yeah, or before you take on the role as executor, you can think about that as well. Just because you're named doesn't mean you have to accept the role. That's why we always recommend alternates as well. But when you're trying to decide if you've been appointed executor, to decide if that is a role you want to accept at that time, you can certainly look into it at that time.
So I think you'd probably put a finer point on this. This person may be worried that whoever they're an executor for may have some debt that
Right.
outpaces or outsizes what might be left in the estate. So
Right.
what would happen in that particular situation, generally speaking?
You can, like I said, just because you're named doesn't mean you have to take on that role. Sometimes it's better to announce as executor and then maybe talk to the public guardian and trustee and see if they're willing to take over, especially if there are more liabilities than assets.
Okay,
Mhm.
great. Any other thoughts from our panel on that one?
I think just to add to that, as an extension, I think sometimes people are afraid there's going to be problems and there'll be disagreements among the family per se. And so again, to reiterate what we've been saying all along is have the conversation in life. Let the kids know this is what we're doing. This is why we're supporting the Pacific Salmon Foundation. Yeah. And so there's no surprises and you really reduce the opportunity for tension, which can result in problems, which probably generated that question.
Yeah, openness is
Yeah.
really important
Yeah.
on all fronts.
Yeah.
Yeah.
Yeah, the will's the legal document that says this is what we want to have happen, but oftentimes it's accompanied with a letter saying, Michael, this was what my thinking was around this.
Yes.
Having that family discussion, we have so many cultural taboos about not talking about this kind of stuff. But hopefully that's going to change in our time as advisors, and we're going to help people have those discussions and help them figure out how to talk to mom and dad about it. So
Well, and are we not facing a huge shift in generational wealth with the baby boomer generation?
That's right.
Over the next couple of decades. So
Exactly.
these things do need to be discussed
Yep.
and prepared for. And certainly the charitable organizations we love in our life should be part of the conversation in the legacy as well. So we're going to end here. This has been a wonderfully stimulating conversation. I thank our panel. We have a question, the last Slido question, and we'll give everybody a crack at the bat on this. This is a bit of a softball. As a young person with no former experience with these things, where do I start? I'd like to set these things up earlier than later, but it's a bit overwhelming. Maybe Gardy and Devinder in particular help this person understand, when they come in to sit down with you to write the plan or do the will, how long is it going to take? How much is it going to cost me? What's the objective? What do I come away with? Gardy, why don't we start with you? Help this person get started. Hopefully they're going to call you.
Right. This is a game of trust. You have to trust the people that you're dealing with. So you want to be dealing with someone that you have that trust with. If you're a Pacific Salmon Foundation donor, call Margaret. Ask her, who should I talk to, Margaret? And she might know you already and be able to say, oh, I think Gardy would be a good fit, or, maybe Michael would be a better fit. Legal documents are daunting at the best of times, but Devinder is going to make it easy for you. She's going to help you articulate your wishes. She's going to help you do it in a format where it's going to be 100% accurate. It's not going to go wrong. There are lots of people out there. Michael mentioned it earlier. You need to just have that discussion with people. If you've got a relationship with a banker, call them. If you ask your parents, who did they use? That might be a way to have that conversation. Ask your children, who they use. So, we find most of the people that come to us, Michael, have been introduced to us by someone else. So, of course, you can go online and Google it and do that. Most people will take a phone call, I'm finding these days, to help answer the questions. They might say, we're not going to be the right fit, but Devinder will be, or she will know someone who will be. So, start with talking to those around you that you trust, and then hopefully that'll lead you to the people that can help you.
Great, Gardy. Devinder, your
Absolutely. Like you said, start with a phone call around and see. A lot of places, including ours, we do like the first consultation at no cost. Start with that discussion. We have intake forms. You fill them out the best of your ability. You have that conversation. And if it isn't the right fit, then we can usually refer you to someone who is the right fit for you, or could be. And that's the first step, is at least recognizing that you want to get it done. And then the second step is a phone call or do research, and just start from there. Just get started. That's the main thing.
Yeah, and as Gardy, thank you for mentioning, we're very fortunate at PSF. We have Margaret Buttner, who is our annual and planned giving director, and she has decades of experience in this. And we've found many occasions where people will phone us first because they're interested in salmon. They want to get their plans done, and then Margaret becomes the connector to a lawyer who knows how to do this type of thing, or a financial planner that has an inclination to support charities. So, you know, I know many charities are beginning to add planned giving professionals to their staff roster. We're very fortunate to have Margaret Buttner, and her information, of course, is available at the end of the program. Please consider her a resource for phoning as well. Mike, I just want to ask you, and this will be the last question, you know, family donor advised funds. People may be thinking this is just for the, you know, uber wealthy. You know, what kind of services does Charitable Impacts provide for maybe this younger person who wants to get started with thinking about not only their legacy, but maybe what they want to do now in life charitably?
Sure, thanks, Mike. I think the way to look at a donor advised fund, or to think of a donor advised fund, it's like a bank account for charity. And so if I've got a few extra dollars, and it can literally be a few dollars, or I've got a few extra thousands or hundreds of thousands, doesn't matter, I'm going to deposit it to this account. And as I said earlier, then I benefit from the tax receipt today. And then I've got this pool of assets that's available to give away. And so don't think you have to have 100,000 or $1 million. We've got accounts with $5 in them, and we're very, very happy to help these people give to the causes that they care about. But think of it as a centralized place. You're not going to lose your tax receipts anymore. You know exactly where to get them. If I lose mine, I just download it again. And I can contribute different assets, cash, publicly traded securities. That's kind of my area. Real estate, you mentioned. Private company shares. We've had a couple people ask us about cryptocurrency even. So it depends on the asset, and you don't have to be an expert. You just need to talk to us, and we can understand what it is you're trying to accomplish, and then decide if it makes sense for you to give now. You can set up a donor advised fund and use it as part of an estate plan, and hold the assets today, and then make sure that they're covered off in your will. So all sorts of alternatives, but I think the key here, as we've learned today, is don't be scared off. It sounds complicated, and it can be, but you don't have to worry. You just need to partner with professionals.
And so what you then do is you will set up that charitable bank account, as it were, and then if an individual says, I want to give to the environment or salmon, a specific niche gift like that, you'll then facilitate the donation to that charity. The individuals already receive the tax receipt when they
That's right.
Yeah. And we do periodically get the gift of securities, particularly ones that have had I think you call it a swollen, growth and gain, and you want to try to avoid having to pay capital gains. That's a great time to give to either you or to us or any number of charitable organizations.
Or they can give it to us, and then we'll give it to you.
And then you give it to us.
Yeah.
And that would be fine as well.
let me just emphasize that point. The capital gain in securities, people often don't know that, yes, you're going to get your tax receipt, but you also get to eliminate the capital gains tax that would otherwise be owed. And I know from experience there's a lot of people writing checks to charity, and that's great, and we encourage that, but it would be more effective and actually more beneficial to donate securities instead. Yeah. And if you've got some stock in a non-registered account, not in your RSP, but in a non-registered account, or write a check, very, very often it makes more sense to actually donate the stock.
Good. Wow, we have covered a lot, and we have in Vancouver or the Lower Mainland such great expertise on this. I want to thank all of our panelists, Michael Todd with Charitable Impacts, Gardy Frost with Arbutus Financial, and Devinder Sidhu, who's a barrister and lawyer in White Rock. This has just been tremendously informative. So thank you also, our viewers, for attending, and we appreciate your interest, certainly in salmon, but more broadly in how you can use financial planning, estate planning to support charitable endeavors. We hope that the program has provided you with some useful tips for how to ensure that your assets are protected, your loved ones are taken care of, and as we mentioned, perhaps your favorite charity like PSF or others are taken care of as well. So again, thank you, Devinder, Gardy, and Mike for this insight and the time today. We are most appreciative. Just a few closing housekeeping notes. Contact information for our speakers is available should you wish to consult with them further. They volunteered their time today, so please consider patronizing their services in the future. Touch base with Margaret Buttner as well. She's our Director of Planned and Annual Giving, and she'll be sure to pass this information along. We hope that you'll visit psf.ca to learn more about our work. And if you'd like a copy of today's presentation, do let Margaret Buttner know as well. So that's about it for us. We are going to give a nice little thank you gift to all of our participants. We have, of course, the masks are the thing now. So we have our psf.ca mask. Each of our presenters will receive a mask and a gift package from PSF to thank them for their time today. And to all of you, be safe, be kind, and wear the mask. Thank you for joining us.